Welcome to the Law Offices of Sabrina Lee's YouTube channel. Sabrina is recognized as a State Bar of California Certified Legal Specialist in Immigration and Nationality Law, a prestigious distinction held by less than 1% of attorneys. Today, we have an incredible successful story to share that embodies our motto, "Your American Dream, Our Commitment." If you found this video valuable, please like, subscribe, and share with your friends and family. The client sought our assistance after receiving a notice of intent to deny her green card application, which had been filed by her U.S. citizen son. In her green card application, she truthfully disclosed that she had been a member of the Chinese Communist Party, CCP, since 1986, until shortly before her immigration to the United States. During her interview, USCIS examined her past membership and noted that it had ended within the 5-year period immediately preceding the filing of her I-485. Shortly thereafter, USCIS issued the NOID, highlighting that her membership was voluntary, not required by law, nor necessary for securing employment, food rations, or other basic necessities. Moreover, she joined the Communist Party or a totalitarian organization because she genuinely believed in the ideals and governance system of that party. Generally, any immigrant who is or has been a member of, or associated with, the Communist Party or any other totalitarian party, or their subdivisions, or affiliates, whether domestic or foreign, is considered inadmissible. This inadmissibility applies to non-citizens seeking immigrant status, including those applying for adjustment of status to become a lawful permanent resident within the United States, applicants for immigrant visas at U.S. embassies or consulates abroad, or those seeking admission as immigrants at U.S. ports of entry. This inadmissibility criterion extends to both current and past memberships or affiliations with such parties. However, there are specific exceptions and waivers available for this ground of inadmissibility. To combat the client's inadmissibility, our firm immediately began working on an I-601 waiver in response to the NOID and the tight deadline given by USCIS. We demonstrated to USCIS that our client had strong family ties to the United States, as she and her son were each other's only family. We also established that our client would be persecuted in her home country because of actions taken since entering the United States. The client was in raptures when her I-601 waiver and green card application were approved in less than a month after our submission. A discretionary waiver is available for certain family members of U.S. citizens or lawful permanent residents. Under the Immigration and Nationality Act, the Secretary of Homeland Security has the authority to waive this ground of inadmissibility for humanitarian reasons, to maintain family unity, or when it serves the public interest, provided that the individual is a parent, spouse, son, daughter, brother, or sister of a U.S. citizen, or a spouse, son, or daughter of an unlawful permanent resident. The individual poses no threat to the security of the United States, and the individual merits a favorable exercise of discretion. When assessing whether an individual poses a security threat to the United States, USCIS considers a non-exhaustive list of factors, including espionage, terrorism, subversion, public safety, including criminal history and gang activity, risks to intellectual property, risks to information security, including disinformation campaigns, risks to election security, and risks to public health. To request this waiver, the individual must submit an application for waiver of grounds of inadmissibility. If you or someone you know is facing a similar situation and needs the expertise of skilled professionals, the Law Offices of Sabrina Lee is the place to seek help. Reach out to us today at 213-375-8096 or send us an email at info@sabrinalee.law.